Next level. Next level.
we ready to start? Hi, everyone. How many of you have been here before? I see familiar faces for our classes. Hi, it's good to see you all. We're not getting older. I was talking to Cindy today and I said, you know, I think I've been coming here for 15 years to do these classes. So it's about that much, and it's just so good to see many of you who I see a lot and new members. So how I do these classes is, you know, I go through a PowerPoint. You can see it on the screens up here. But you feel free to ask questions along the way, and we will do that. Also, one thing that I'd ask for you, because I'm an attorney that represents associations all through the Aspen, this whole area, Basalt, you know, I'm talking generally about fiduciary duty and HOA governance, so I'm not going to answer questions where I could potentially have a conflict of interest. So keep your questions general, okay? And I'm happy to talk generally today about governance. So how many of you are board members? How many of you are managers? How many of you are homeowners? Okay, how many of you love your community? Yay! How many of you, could be better? Okay, there's a few of you. Okay. All right, I just want to kind of get a sense of the people, all of you here, and what your experiences are, what you do in the association context, because all of the things I'm going to talk about today are not only for HOA boards and managers, but homeowners need to understand it too. So go ahead, Cindy. So the first thing that you need to know about just basic HOA governance is HOAs are governed by the documents of their association. So you as homeowners need to make sure you have these documents. And if you're on a board and you walk into a board meeting or turn on your Zoom now, I rarely go to in-person meetings anymore. That's the only nice thing about COVID. I used to live in my car and had 3 and 4 evening meetings a week. And now I just hop on Zoom and it's nice. But you need to have the governing documents of the association, because if you don't have them, you cannot govern your community. It's impossible. Or if you're trying to govern your community without your governing documents, 9 times out of 10, you could be doing it wrong, okay? Because the governing documents of an HOA are what tells you what the insurance requirements are, maintenance requirements are, use restrictions, how the board is comprised. And so this is the list of governing documents that you should have. And how many of you are A.P.C.H.A communities? Okay, good. They have the governing, A.P.C.H.A has the governing documents on the website.
We used to.
You don't anymore? Okay, is that gonna happen again?
Because of the new regulation that Colorado has put through for public entities, it has to be ADA compliant. And because we don't control a lot of those documents, it's going to be like a 5-year plan before we can start to get them
all right. And Cindy, for A.P.C.H.A communities, where do they go if they need their governing documents?
Well, everything, they should have gotten all of them when they closed.
Yeah.
But we do have them. If you need them, we can probably provide them to them.
Okay, all right. So the first document is called the Articles of Incorporation, and that's the document that creates your HOA's corporate entity. 99% of HOAs in Colorado are nonprofit corporations under the Colorado Revised Nonprofit Corporation Act. You don't have to remember that. I will not test you on this stuff. But the Article of Incorporation just creates the common interest community. There's typically not that much in there that boards need to know, but you should know that that's what creates your common interest community. And HOAs are called common interest communities. It's either a condominium community or what they call single family home community. It's either single family planned communities. It might be townhomes that have attached, you know, party walls between them. The next document, which in my opinion is the most important document that you have to have, is the declaration. How many of you live in condos? Most of you, I bet. How about single-family home communities? A few of you. Okay, so for a condominium project, it's usually called the condominium declaration. And just so you know, my pet peeve is when people say declaration with an S on the end. It's singular, it's a declaration. And everything in it is the covenants, conditions, and restrictions. So a condominium declaration typically has condominium declaration in its name. Single-family home communities, it's typically called the Declaration of Covenants, Conditions, Restrictions, okay? And it might have a weird name because you've got some old documents up here that I deal with that kind of sometimes will be called protective covenants. You might hear that term. All right, the next thing is a map, and maps are extremely important. For single-family home communities, it's a plat map, and it shows where the lots are. It shows where the common elements are of the community, if you even have one. In the condominium context, it's extremely important, too, because it shows the unit boundaries typically. It will show the common elements, the general common elements that everyone has the use for, and it will also show the limited common elements that are pertinent to a particular unit, which means they're for the exclusive use of one or more units, but less than all. So that might be a balcony, a deck. That's not part of your unit in a condo project typically. It's part of the common elements. And just FYI, you can tell people at a cocktail party, you know this, who owns the common elements in a condominium? The owners do. Very good. Because people think the association does, but the owners own the common elements based on what's called their allocated interest. It's a percentage interest that's specified in the declaration. The next one is the bylaws. The bylaws are the governance document that says how the board is elected, how many directors, what their terms are, what happens when there's a vacancy, how you remove a director, all of those things. Sometimes they'll have also the powers of the association in that document, but it's your governance document, okay? And you can't have an election of directors or send notices of meetings or anything like that unless you're consulting the bylaws, because all the information you need is in those bylaws. The next is the rules and regulations. Under Colorado law, the boards of HOAs have the ability to promulgate or create rules and regulations for the community. Here's a little key, board members and management. Your rules and regulations cannot trump a provision of the declaration. So let's say you have a provision in the declaration that prohibits dogs or any kind of pets. You cannot promulgate a rule that says you can have 2 pets and the dogs can't be more than 25 pounds and that kind of thing. So you can't try to get around the declaration through the use of rules, and that's because the board adopts rules and amends rules, but to amend the declaration requires owner consent. It's typically 67%, but there's all sorts of, rules on that. So if you're ever in the process of trying to amend your declaration, talk to an attorney and get some guidance on what that amendment process requires, okay? Because we have statutory rules that regulate that too. And then the policies, could you hit the next slide? Policies in Colorado, unless you're a very small community, there's 9 responsible governance policies every community association, whether you're a condo or a single family home plan community, are required to have. The first one is a collections policy. So if you're attempting to collect delinquent assessments, you need an updated collection policy. FYI, the laws just changed on August 7th of this year in terms of how you give notice to delinquency to delinquent owners. So you're going to need an updated collection policy. Yes?
Molly, I'm sorry, can we go back for a second? In your rules and regulations and your bylaws, how should we handle therapy, emotional support?
Oh, it's always a great topic, and we should do that again. So the question is, how do you handle therapy or support animals? And that's interesting. So the Federal Fair Housing Act applies to all HOAs in Colorado, okay? And so if your declaration or your rules prohibit certain types of animals, under the Fair Housing Act, an individual can request an accommodation if they have a disability-related need for that animal. These animals do not need to be trained as service animals. That's the Americans with Disability Act. That doesn't apply in a HOA in Colorado. And so, you know, and it can be for, I hear up here all the time, you know, and I've said this before in a class, I'll never forget, and I'll say it again. You guys live in paradise up here, in my opinion. And we have a lot of very depressed people. And I believe the reason is not because they're depressed, because they know under the Fair Housing Act, when dogs are prohibited, they can get you know, an accommodation to permit an emotional assistance animal in HOAs. Everybody knows the loophole up here, right? But the Fair Housing Act and HUD has tightened up those restrictions. So if somebody does need an emotional support animal, that falls under the Fair Housing Act, or they have a disability-related need, they're blind. I've seen a lot of amazing dogs that handle, oh geez, help me guys. Seizures. Yes, I had a mental seizure for a second. But seizure dogs are amazing. I've seen them sit people down in HOAs, and then they have a seizure. So there's a lot of really good reasons and need for assistance animals. And if they go through the steps required by the law to request an accommodation to have a service animal that is normally prohibited in an HOA, the association is required to grant that accommodation, and board members and managers, if you go through that process under federal law, you are not permitted to share that information with any other owner or anybody. That is strictly confidential information, okay? So where were we? Okay, yes.
Does this mean the association cannot ask you a certificate? Can you get the dogs?
So if you, the certificate you're asking, does that work? It used to be everybody would pay $50 online, get a certificate that says I need a disability, or I have a disability and I get a service animal. HUD finally said, no, that's not enough, okay? But just really quickly, and we can do a whole class on this another time, if a person with a disability, their disability is known, okay, by members of the association, if it's visible, you can see the disability, and the need for the assistance animal is obvious, you cannot require documentation from some type of professional with knowledge about it, okay? So if you're getting a request for an accommodation, make sure, you know, you talk to, I'm not saying talk to me, talk to an attorney if you have one up here and get some guidance on that. Because if you don't grant it and there's a real need for it and a disability-related need for it and the animal is serving that need, you can end up in a real problems with the Colorado Civil Rights Division. And that is not fun. I've represented associations. They go through everything from the beginning of the association to present time, and it's just not fun. Okay.
Quick question, and then
Yeah.
I know you don't want to spend too much time on pets, but can you charge people if you have a standard pet fee?
No.
Okay.
If you have a standard, if you do allow pets and you have a pet fee, which many associations do, for somebody with a disability-related need for an assistance animal, you cannot charge them.
Including emotional support.
Emotional support is included in that. For some reason, everybody calls them ESAs up here. You know, that's a category of an assistance animal.
Can you require a certificate or something?
You can only require documentation when the disability is not known or apparent, and the need for the assistance animal is not needed or known or apparent.
Is there any age requirement? I got a person that has a problem, have a puppy. They have a dog now in our association that's old and is gonna probably have to be put down, and they're probably gonna wanna get a puppy.
Uh-huh.
And puppies aren't really trained at all.
If somebody requests an assistance animal, first of all, it's not unusual for them to have more than one, okay? Different assistance animals might provide different assistance to the person with the disability. If somebody requests a puppy and they've got an emotional issue and they need a support animal, and emotional support animal, an ESA, then, you know, you just need to have a reasonable discussion with them. I would not prohibit it on its face, but have a discussion, because you can require the owners to pick up after their dogs, to make sure they're not a nuisance and aren't barking and all of those things. So everything when you're dealing with assistance animals under the Fair Housing Act, it really is on a case-by-case basis, and you have to look at the specifics. Okay, really quick back to the policies. I'm not going to go through all of them, but I just want you to know these are 9 policies you're required to have under Colorado law. An enforcement policy, conflicts of interest, when the board has a conflict of interest, what they can and cannot do. There's a policy that regulates adoption, an amendment of policies, procedures, and rules. Conduct of meetings, those of you who've heard me talk before, I think that's the most important policy, frankly, because sometimes meetings get out of hand and you get somebody who's abusive in a meeting. That conduct of meeting policy deals with issues relating to that. It also talks about open meetings that are required in Colorado, and it will also discuss at what point can you go into an executive session and remove the homeowners from the meeting. So that's a really important policy. There's a reserve fund policy, yes?
You're not gonna cover anything regarding enforcement, so if a board refuses to enforce anything.
That's a whole class in and of itself. I could talk for a half a day on enforcement. So, I mean, boards have a fiduciary duty to enforce the use restrictions and rules. That's why rules, guys, if you've got rules that don't fit your community, get rid of them. The board can do that without a homeowner vote. And if you've got old use restrictions in your declaration that don't fit the community anymore, think seriously about amending the declaration to deal with that. The problem with enforcement in Colorado is in 2022, the legislature passed a really difficult bill that makes it so extremely difficult to enforce anymore that a lot of community associations just, they'll send a notice of violation, but there's, you know, a lot of my clients feel like there's not much they can do that's effective over and above that. We can talk about enforcement at another class too. There's a reserve study policy, a dispute resolution, alternate dispute resolution. I talked to a state legislature. I'm on a stakeholders group, and she's planning to run a ADR, alternative dispute resolution bill, where homeowners or associations can request dispute resolution early on if there's a dispute. I happen to think that's a good idea because of my 17 years of experience. What happens when people get angry at each other, the boards and homeowners, is they put their feet in concrete, and it's hard to resolve issues when everybody's angry. So the earlier you can get people to sit down together to try to work through things, in my opinion as a practitioner, the better. And then there's a records inspection policy. There's a statute that a team of us actually drafted and was passed several years ago that talks about the records which owners are permitted to request under Colorado law. And so your records inspection policy should cover everything you need to know about that. So those are the policies, go ahead, Cindy, the policies that you're required to have. Yeah.
So the board, if your homeowners association refuses to do anything, refuses to enforce anything, refuses to communicate, has no meetings, is charged a minimum amount, they will not provide any documentation, no governance, no records of what they do privately, no open meetings, nothing. What are your options?
Run for the board, number one.
They don't even do that. They pick each other. They select each other, and they're all part of the.
There's no election?
No.
I had the same issue in election. I was even to be elected, not at myself a year ago. This year was just, again, I can't
Okay.
get any treasury reports or anything.
Okay, you know, you can bring a lawsuit against the association, which is expensive. You can also, under Colorado law, remove directors from the board with or without cause. So if you have a board that's not doing anything or is abusing its power, I mean, there's a process that you can go through by statute to get a petition to request a special meeting of the members, and then and then the board will have to, under Colorado law, hold that special meeting, and then you can go through the removal of directors process. In 17 years of practice, I've never had a removal. But that's because they have an attorney and I tell them what they have to do, you know.
But they won't provide insurance documents, they won't provide who the attorney is. Is there a state agency you can contact?
There's a state agency that you could contact that could tell them, and that is under DORA, the Department of Regulatory Agencies. There's the HOA Information and Office and Resource Center, and they may be willing to provide information to the Board of Directors on that. It's the HOA Information and Resource Office within the Department of Regulatory Agencies, DORA, for the state. Okay, so let's talk about fiduciary duty of directors. So how many of you again are on boards? Yeah, okay. So you have a duty of care, a duty of loyalty to the association, and a duty to act within the scope of your authority. Could you hit the next slide? Okay, a duty of care. And this will tell you, I'm 60, I'll admit it. I went to law school years ago. And when I went to law school, they talked about the duty of care as the reasonable man standard. We don't use that term anymore. And I always tell my husband, men aren't reasonable. Sorry, guys, I don't believe that. But anyhow, a duty of care the duty of care means that you have the duty of care to act as people on other HOA boards would have, to be educated about your governing documents, to look at them. And the duty of care, you wouldn't have the same duty of care that I have as someone who specializes in HOA law. You're not expected to know Kiowa, know the Nonprofit Act, but you have a duty of care to act in the best interest of the association. So you have to act as an ordinary, prudent director in the best interest of the association and to act in good faith. Sometimes, well, I'd say many times, folks get on boards of directors because they have an issue they're passionate about. That's not wrong, that's fine. You know, we all have issues that we care about in the association context. However, when you act in good faith, you're acting in good faith on behalf of the association as a whole and not your personal interest. So, you know, once you get on the board, you have to say, okay, well, maybe we can do something with this, but I understand my duty is to the association as a whole and not to myself. Go ahead, Cindy. So how do you fulfill your duty of care? First of all, you better be having meetings, because if you don't have a meeting, you're not governing your communities, okay? I prefer, look in your bylaws to see if there's a specified number of meetings you should have. You know, not every association has enough they're dealing with that they have to have a monthly meeting. I prefer my clients to meet quarterly at least, because you're going to look at the finances of the association, you're going to see if you have delinquent assessments, you're going to talk about maintenance issues, all of those things. And you know what? I hate it. It used to be when we actually met in person, I would see directors walk in with a board packet and a manila envelope and they'd be opening it for the first time. You know, they don't know what they're going to be talking about. They haven't even looked at the documents. So I really want my boards, and this is my preaching to my clients, I want the board members to be prepared, to have looked at the agenda, to have looked at any additional information the association has, or the manager has given them. So it's really important to be prepared. Also ask questions. So if you've got a manager and they're, you know, giving a report, ask them questions about things that are going on. Ask them if you've gotten homeowner input on issues, if you've gotten complaints. So if you don't have the information you need, ask questions and you know, don't act until you have all the information you need. Obtain advice from professionals is necessary. You know, the beauty of talking to professionals is, and it could be an engineer, it could be a general contractor, it could be an accountant, it could be a lawyer, it could be a variety of different people. If you have a right to rely upon the advice of your professional, and it gives you immunity even if that professional was wrong. Okay, so if you have a specialized issue and it's not just your normal run-of-the-mill issues, ask professionals for input. Be informed before acting. So I see boards at two extremes. One is a new issue comes up and they just make a decision, and they might not put a lot of thought into it. They might not ask for a lot of information. So make sure that you're well informed before you make a significant decision. And this could be major maintenance, major repairs. Do you have the money? Who's going to do it? You know, do you need an engineer? All of those types of things. And then I have the other extreme, and I want to leap from a bridge when I'm at these meetings. Have you ever been to a board meeting where they kick the can down the road and they never make decisions? And they beat a dead horse meeting after meeting after meeting. They've got all the information, but they just can't bring themselves to make a decision. I mean, as directors, you've got to make decisions, but just make sure you're well informed. Exercise independent judgment. Have any of you been on a board where there's somebody that knows it all and controls the entire meeting? Yeah. You know, and you want to smack them, you know? And sometimes those people can be so abrasive that they make it uncomfortable for the other directors to really participate, ask questions, and respond. You know, just grow a spine with those people and just say, you know, you've had your chance to speak. I have questions and I have this input. Anybody else? So, you know, really the importance of board meetings is for boards to meet, to discuss together issues, to come up with a solution to the issues you're looking at. Okay. Duty of loyalty. All right, so if there's one thing you remember, boards, management, you have a duty to the association as a whole as opposed to individual owners, okay? And that's hard, especially in smaller communities where, you know, they're your neighbors, right? And so they'll catch you at the mailbox, they'll catch you going into your house, and they'll, you know, say, oh, you should do this, I need this. You know, you might have family members that live in the community, and they might want something that's not necessarily in the best interest of the association as a whole, or other people have other interests and groups they're aligned with, and they may ask the board to do certain things. Remember, you are acting in the best interest of the association as a whole, as opposed to anybody's individual interests, okay? So keep that in mind. Oh, go ahead. Okay, one of the things, this was when I was a baby lawyer here. I represented this big active adult community, and it had a golf course. It was a great community, several hundred homes, and I was doing board training. And I was talking about, you know, this, you have to act in the best interest of the whole. You also need to, when a decision's made, you need to support the decision by the board and not actively go out in the community to try to undermine what the board decided. If you feel like you have to undermine the board action, then you need to resign from the board before you do that. And so I'm in front of these meetings, they would get 300 people, 300 homeowners. And I'll never forget, and I was actually kind of young at the time. I'm not anymore, but one of the directors said, so when we're done with this meeting, I can't go out and have a cocktail on the porch and talk about how much I hate the decision the board made. And I said, no, you can't. You know, you're violating your duty of loyalty to the association. My favorite person in Aspen. So good to see you, Pam. So anyhow, in terms of your duty of loyalty to the association, here's some things you need to keep in mind. First of all, I don't want you to be doing your governance via email. I know in this, or text now, right? You know, if the board is discussing issues, discuss them at a meeting. Because I want you to have the opportunity to hear each other, speak to each other. It can be on Zoom, it can be on the phone, but the other thing is, homeowners have a right to attend board meetings. And if you are not discussing and passionately debating issues, if it's a significant issue, at the meeting, and the owners can't see that, trust me when I tell you, they will think there's some conspiracy going on, okay? So you should be having transparent board meetings. Owners under Colorado law have a right to provide input at board meetings before the board actually votes on a decision. So let's say you're making a decision to, I don't know, paint the exteriors of 3 of your buildings. So you have a motion, a second, and then before the board votes on that motion, the owners have a right to speak to that issue, okay? And you should, as directors, want to hear what the owners say, okay? So, and then again, once a decision is made, speak with one voice. You know, don't go out and undermine the decision of the board. Don't. That is a breach of your duty of loyalty. It's a breach of fiduciary duty to the association. And then handle conflicts of interest appropriately. So I deal with conflicts of interest all the time. I get questions on that. So how I think of as a director, a board member has a conflict of interest is if their interest in the outcome of something the board is voting on, the outcome of the resolution, is different than everybody else in the community. If they have a personal interest in the outcome, it could be financial, it just could be enforcement. I have beagles, and if I were on the board of my HOA and somebody were going to complain about my barking beagles, which they just never do, of course. And they're voting on whether to fine me for that. They've gone through all the required processes to do that. Obviously, I have an interest in the outcome of that, so I should not be, other than speaking as a homeowner in my defense, I should not be discussing it with the board, and I should not be voting on it. And remember back to that slide I had on the non-responsible governance policies. One of those is the conflict of interest policy. Also up here you will find that some members of the board might own companies that could provide services to the association. They might own a landscaping company, for example, and they want to handle the landscaping for the HOA. If the board wants to consider them as a contractor, they can do that, but that director who owns or works for the company or has a financial interest in the company should recuse him or herself from that and not engage in the discussion or the vote on it, okay? So that's important to really recognize when there's conflicts of interest. Go ahead, Cindy. Okay, boards can only, and remember I started this out by saying a board cannot function unless it is acting within its scope of authority, and I talked about the governing documents. You cannot know what you as directors have the authority to do unless you look at the governing documents, okay? And so that's good. The Articles of Incorporation, not so much. That's what created the association, if you remember. The bylaws may have the powers and duties of the board of directors in them. I tend to try to keep it in the declaration, but a lot of bylaws have powers of duty. And then the declaration is the condominium declaration or the declaration of covenants, conditions, and restrictions if you're a single family home community. That will specifically tell you the duties of the board, okay? And so it's things like collect assessments, maintain the community, carry correct insurance for the community, all sorts of things in those powers and duties. So you need to know what you have the authority to do, guys, you know, so that you're not acting outside of your scope. And then there's authority granted by state law, by statute in Colorado. The Colorado Common Interest Ownership Act, it's 38-33.3-100, all the way through that statute. That is the governing body for associations, for HOAs. They're called common interest communities in the statute. And there's two types of common interest community. And so remember, you're going to make sure you have your governing documents, and you're going to go back and look at your declaration. If the declaration was recorded before July 1st of 1992, you are called a pre-Kiowa community. That means only some of the provisions of Kiowa actually apply to your community. And if your declaration originally was recorded on July 1st of 1992 or after, you're called a Kiowa community, and all the provisions of that body of law are going to apply to you, okay? And I think we have, I'm thinking we should get some blogs or something to put up on A.P.C.H.A.'s website so you can go and get more information on that. Okay, go ahead. So those two statutes and the Nonprofit Act, they also have in them authority for boards of directors of nonprofit corporations, which almost all HOAs are in the Nonprofit Act, and then Kiowa has a whole specific section on the scope of authority for HOAs. All right, fulfilling the duty to act within the scope of authority. I mean, one of the big things, especially if you're a self-managed community, I call it the sniff test. If you're like, I don't know if we can do that, find out. Look in your governing documents to see if you have that authority. If you need to consult with a professional, you should consult with a professional. But if you are kind of tentative that you don't think you have some authority that people are asking you to exercise, then find out before you exercise it. Always, always, always consult the governing documents. I used to say, take your folder of documents, take your iPad or whatever it is, wherever you can electronically access those governing documents, the statutes. And again, if you really feel like you're on shaky ground and are going to be making a significant decision, you may need to consult with an attorney to get advice to make sure you're not exceeding the scope of your authority. Okay. All right, here's some examples of breach of fiduciary duties, particularly in condo projects. The failure to maintain, repair, or replace the components the association's required. You know, one thing I'm seeing is, and this is statewide, is that association boards don't want to increase dues, called assessments. I mean, do any of you feel that way? Because you all have to pay them too, right? And so nobody likes to see their assessments go up. So as a result, a trend I see is deferred maintenance. You know, so they're not maintaining components the association's required to maintain on a regular basis. And it can be a breach of fiduciary duty, but we're now getting into this problem that so many people have put this off for so long that how do you possibly come up with the funds to handle these? So it's something actually that the legislature is looking at too in Colorado. There's going to be a reserve fund bill this next session. Failure to plan for, fund for reserves, and or use of other financing vehicles. Who knows what reserves are? Okay, so reserves are not for your routine maintenance that you carry out on a yearly basis. That's typically going to be put in your annual budget, all right, and covered through normal assessments. Reserves are for major repairs and replacements for components the association is responsible for. So in a condominium project, it's roofs. It might be asphalt on the roads, really high ticket, major repairs or replacements. Those are typically going to be covered in part by reserve funds. I know that there's a problem with a lot of associations don't reserve at all or at very small levels. Currently, under Colorado law, there's no requirement that associations fund reserves at any level. But if you've got major financial difficulties, in my opinion, you can get in a breach of fiduciary duty if boards are deferring maintenance and those components that are going to have to be replaced sooner or major repairs, and they don't have any money in reserves and you don't have any money for it, you can get into potential breach of fiduciary duties. Then you're looking at special assessments, you're looking at loans. Loans are really a good thing for associations if you can afford them. Right now, even though the Fed just dropped the interest rates by 0.5%, the interest rates for HOA loans used to be about 4.4% or a little above. Now they're 7% and above. And so if you would have to increase assessments to pay the principal and your interest, I mean, you're going to look at a financial crunch, you know, one way or the other. The other thing, and I hate going to these meetings, are special assessment meetings. I'm going to a lot of those meetings where something has to be done, it's been put off, and they have to levy a special assessment to do it. And that, you know, anything with a pocketbook is no fun. Failure to appropriately, yes.
Is it true special assessments don't have a time frame?
It depends on your declaration. So remember, the Colorado Common Interest Community Act, Kiowa, that, believe it or not, that's the body of law in Colorado that regulates HOAs, common interest communities. There is not a reference in that statute to special assessments. So you don't have statutory authority to levy a special assessment. Instead, you have to look to your declaration for the authority to levy the special assessment and the language it has in the deck. So it may say you can levy it for a period of 1 year, you can do it for a larger period of time. So that's going to be really document specific to every HOA. And also the process you have to go through to levy a special assessment is going to depend upon what the process is in the deck. It used to be when I was a baby lawyer here and starting out in this area of the law, we used to do these provisions that said, in order to vote on a special assessment, you have to have 67% of quorum of the members at the meeting, and a majority of those owners have to vote to approve the special assessment. And if you don't get quorum at the first one, you can cut the quorum down. If you have another meeting within 60 days, you can cut the quorum in half. Well, I'm here to tell you, you never make that first quorum, you know? So now, you know, probably the last 5 or 7 years, when I draft budget provisions and special assessment provisions, I have the special assessment be handled through an amended budget of the association, and then I use the Kiowa budget ratification provision to do that. And the Kiowa budget ratification provision says you give notice, so you do an amended budget with a special assessment, you give notice of the special assessment, the owners then vote, and if you have less than 51% of the owners vote to veto the amended budget with the special assessment, it's automatically deemed approved. So it's kind of counterintuitive. And under Kiowa, for budget ratification, you don't have to have quorum. So the reason I do that is because, you know, before with these massive quorums, you can never get enough people to even vote on it. And typically, if you're doing a special assessment, you really need to get it passed, or you really need to get funds. But the best thing to do, guys, is financially plan into the future with a reserve study. Yeah.
Move money from reserve fund to pay for a special assessment without?
Not a special assessment. You can, here's what I see, and I require my clients to take a loan from the reserve fund. You can take reserve funds and put them in the operating account to cover deficiencies in operations for a year. Let's say you had a massive snow year and there's not enough money in the operating budget to cover all your extra plowing. You can take a loan from reserves, but you need to pay it back.
Who approves that? Just the president?
The board of directors.
So it has to be
Yeah.
approved.
Yeah. Okay. Yes.
We had a very high major repair, and the money was borrowed from the reserve,
Uh-huh.
and a special assessment was approved for the HOA and homeowners. You know, with them at
Did they pay back reserves?
we're right in the middle of this right now. But,
Okay,
I'm the same boat.
okay.
Are you good in Mitchell? Anyway, so we have asked and asked, but he refuses.
Those are part of the financial records of the association. You can request review under section 317 of Kiowa.
A homeowner can request?
Yeah.
But even though you requested, he won't give you that information.
Is this a manager?
It's the property manager. And I was told,
Does his name start with a W? I'm just saying, I'm not saying the name. Yeah, those are records of the association you are legally permitted to inspect and to see. You know what, this lady here has an attorney that represents homeowners, so if you could, when we're done,
I'll just say, I'm in a situation that is a complete nightmare, because I've lived in Brush Creek for 41 years, own my home, and the board there refuses to do anything. And I just had to spend $20,000, and you probably aren't aware of this, that an owner can sue another owner for a violation regardless of the board. And, yes, and I've had to pay a lot of money. And, I found out, the lawyer in Glenwood, this is all he does. He's really nice and really good. And, I found out that to confront the board, if you want documents, for my case, you have to send out a certified letter. You know, not email, it has to be certified to the board. They have a certain amount of time to respond and send you the information. They won't give me anything.
and if they don't, the reason you send it by certified mail is the statute says that. If they don't, you can get damages from the association.
They won't provide anything.
So, I'm sorry, you know what, so boards, I also want you to know this. You have a right to review all of the records of the association, and a manager cannot withhold that information from you. You need it to do your job, okay? So if you have a problem with a manager who's not providing access, then the board needs to think about finding a new manager, because the association's gonna get sued. You can't, manage your association without the adequate records of the association. So I don't wanna throw names out there, okay? That's unprofessional of me. Yes?
I just had some general questions related to financial management as it comes to, so I think a lot of, and you touched on some of it, a lot of the HOA communities locally are small, so they might.
And they're self-managed.
Small, either self-managed, if they grow up a little bit, maybe they have a manager, but I think very few hit the threshold of having an annual audit within, the.
You're not required to have an audit
But
under Kiowa.
if you're self-managed, what's the duty of care of the boards to have to maintain these records, especially if you're self-managed, and especially if you're not getting
Yeah.
professional help from
A CPA or accountant or bookkeeper.
yeah.
Or,
hey, do you have a capital replacement study policy that?
a reserve study policy. Yeah.
An audit as a footnote that you're not getting, what's the
So,
area in between there for these?
it doesn't matter if you're small and self-managed, or if you're I live in a community of 2,000 homes, it's an HOA. The boards have, and they obviously have professional management, the boards have the same responsibility to ensure the records are maintained and produced to owners when they are requested, consistent with the records inspection policy that you're also required to have, okay? And so, things that I want all my boards to do, regardless of if they're self-managed, so you have, in any association, you have normal monthly expenses, okay? And it might be water, whatever. You've got just routine monthly expenses of the association. You can delegate the duty to a manager to pay those normal monthly expenses without the board reviewing them, but anything that is not a normal routine expense of the association, I want my board, at least the treasurer and the president, hopefully the whole board, to be looking at invoices for all the expenditures that are not ordinary monthly expenditures, and approving them before either the manager cuts the check or makes an electronic payment, or a member of the board or the association who's handling it in-house. I know this is a pain, and it's not necessarily easy to do, but I also want, if we've got large checks going out, I want 2 members of the board signing those. I don't want somebody just writing big checks without it being approved, and I want directors signing it. I know that that is difficult, especially if you're in a community up here where it's second homes, and your directors, you know, might not be in-house. They might not be in Aspen. And so there's ways you can do that electronically. You know, they can still review documents. And you need to maintain those records. You know, a record, you should have, for every expenditure, there should be an invoice. That's just basic. Those are records which the owners have the ability to request. So if you've got any questions about whether your finances are being handled appropriately, whether it's just somebody just isn't an expert in it, or if you think there's something that's not appropriate going on, you don't have to have a full audit, but I'd have, you know, a accountant go in and do a review of the records. Yes.
Molly, wouldn't most of those financial things be in the annual disclosure?
No, they aren't in the annual disclosures. Did you know there's an annual disclosure requirement? Okay, so this tells you how antiquated the statute is. You can either have it electronically or you can keep a binder of records. And it's like, who keeps the binder, you know? And I've never seen in almost 18 years anybody look for the binder, but it's things like the declaration, articles of incorporation, bylaws, rules and regulations, certificate of insurance. But the financials are not part of those annual disclosures. Those are records that owners should, if you have questions, just request to inspect. And check and see if your association has a records inspection policy. Okay? Yes?
I read on your website, now maybe this has changed, that at least a review of the finances of the association, are now required or often requested by a potential buyer as part of the.
Oh, they get a budget, but we don't do. No, the association's not required for purchasers to do a review of financial records. But, for large associations, I want an audit probably every other year, and I want reviews of financials in between. So it just depends on the association, but the boards have a duty to ensure the finances of the association are being handled appropriately, and you are keeping records of the finances of the association. Okay? No.
Because that's, I think, where you get into a lot of trouble.
Yeah. So if you're self-managed and you don't have somebody who has some kind of bookkeeping background, I recommend that you look at hiring a bookkeeper to maintain your financial records. But that's entirely up to you. Management companies will typically do that for their associations, do financial management. Bad math become? I don't know. Typically, fraud is when somebody intends to defraud somebody, and so they're misappropriating funds or those types of things. So, anyhow, yes.
I heard, and I can look it up on the A.P.C.H.A website, that A.P.C.H.A will do audit. Is that true?
Cindy says no. No.
Someone said, why don't you have A.P.C.H.A do a free audit?
Because they don't have the experts either, or the time.
If your association hires an accounting firm to do the taxes and, take the $50 a month, a year, or whatever, as an owner, can I request that information from?
No,
Or the
you
county?
have to request it from the association.
From the board.
Yeah. Okay, let's go to the next slide. Okay, so boards have the protection of the business judgment rule in Colorado when they are fully informed and they're making good decisions based upon their business judgment. So remember I said earlier, I have two types of boards. One that, well, I have some really good boards. So the type of board that just makes a snap decision on a big issue and they haven't done their due diligence. Let's say we need major roof replacements. They haven't gotten bids from contractors. They haven't had an engineer look at it to see if it's even necessary, or an other construction professional. So it's important to do your due diligence on decisions. And then I've got the boards that they could not make a decision to save their souls. And they will just be like a gerbil on a treadmill going round and round and round and round and never make a decision. The business judgment rule provides protections to directors and HOAs if they are doing their due diligence when making decisions, and they make it in the best interest of the association in their best business judgment. Okay? And also, something that can feed into the business judgment rule is, remember when I said another level of protection in the HOA context is when you receive advice from professionals, you're permitted as a director to rely upon the advice of experts, okay? And that might be an engineer. In a lot of cases, when I'm dealing with my clients, they've got major construction projects going on. So following the advice of an engineer, an accountant when there's financial issues, an attorney if there's a legal issue, that will add some protections for HOA boards. Go ahead. Other protections of boards and individual directors. Have you heard of D&O coverage? It's directors and officers liability coverage. Every HOA should be carrying D&O coverage. Because if you're sued as a board or as individual directors, a lot of times a lawsuit will name both the association and the individual directors. Your D&O carrier typically will step in to give you a defense. So they'll hire a lawyer, your insurance company, to give you a defense. There's indemnification provisions under Colorado law, and it's usually also in your governing documents, that if the board is acting in good faith, they are not engaging in gross negligence or willful and wanton misconduct. If you're sued and there's ever a judgment, typically under the indemnification, the association, if you don't have D&O coverage, which you should not have D&O coverage, make sure you have it. The association would then step in and provide a defense and, payment of damages if there are any. Here's something that I think is one of the best ways for boards to protect themselves, is to be really transparent in your actions. Govern at board meetings. Discuss issues at board meetings. Communicate with the owners that there's a big issue that has to be dealt with, so that everybody knows what's going on. They can attend board meetings because they're open if there's an issue. So let's say we have a huge expenditure coming up. We're gonna have to, we have all of our siding is leaking in our condominium buildings, which is a general common element typically, which the association's responsible for, and it's gonna cost us $3 million. When you're really working through those issues, make sure you're working with professionals, you're doing it in an open meeting, owners are there to see it. The worst thing that can happen in an association is when the board knows there's a huge issue, and typically that includes a huge incoming expenditure, and the owners know nothing about it. And then they're broadsided with a major special assessment or something along those lines. So, I know it's easy in this day and age. If you're my client, don't ever text me, because I can't save that in my practice management system. But I know boards text each other all the time, or they do it all on email. that is not a great way to govern when you're dealing with huge issues. You need to be sitting with one another, even if it's via Zoom, to discuss this, to discuss the issues, to let owners in on what's going on so they can observe and ask questions at the appropriate time during the board meeting. Yes?
So we just very recently had a sort of civil issue with some homeowners. And I have just this morning sent to the owners that were involved in this, a little, sorry, this is going on, here's what's being done.
Yeah.
Should I have sent that to everybody in the entire complex or just those involved?
I mean, it's kind of a judgment. I mean, if it's like just an enforcement issue with owners or a maintenance issue relative to their particular unit, you don't need to send it to the entire community. But I mean, if there are big issues that are not your ordinary day-to-day type of issues you have in the HOA, I think the more you communicate to the owners, the better. Here's another thing I don't want you to do, and I preach to my clients on this. So Colorado, Kiowa requires meetings of the board of directors to be open. So I have boards say, well, we don't want to be interrupted, so we're going to do this work in a work session. Don't do that. You know, I mean, if you can't control your owners, follow your conduct of meetings policy and let owners know when they're able to speak at a meeting. It's when you make decisions before a final vote. Also, this isn't statutory, but it's standard in the industry. There's always typically an open forum at meetings where owners can speak. And your conduct of meetings policy will also give you kind of the rules of the road. You can't interrupt, you get 3 minutes, you know, stuff like that. So I mean this. I think that's one of the most important and most underutilized policies for HOAs. I mean, the other thing is that's interesting, Kiowa regulates so much, but did you know there's no definition of a meeting in it? So those of us who specialize in HOA law have always said to our clients, a meeting is where the board is making they're taking action, they're making decisions. And the thing I worry about relative to work sessions that might not be open to the members is, are you really not making decisions there, guys? You know, so just be very careful. I'm all about transparency. I'm all about dealing with issues as soon as they arise. You know, if you use a lawyer, it's better for us to help you avoid problems than to unravel problems. So just be proactive, transparent, and open, and that will also protect you as directors. Okay. Tips for boards in creating functional communities. I just talked at length. Give owners a heads up on issues. Hold open meetings and be transparent. Give owners an opportunity to be heard. And if you do that 2 or 3 minutes, everybody gets, 2 or 3 minutes to talk. Even that pain in the rear end, who every HOA has one, who wants to talk and interrupt and, be a pain in the rear end, they should also get a chance to speak their 2 minutes. And trust me, those are the owners who everybody, when they're at a meeting, when they go on and try to take things over and accuse people, look around you when those people speak. Most people are rolling their eyes and they're thinking, oh, there she goes again, or there he goes again. And here's the other thing, guys. Listen to what the owners have to say. I have been guilty of this in my own practice. I know what I want to say. I know what my clients want to do. And so I don't want to take the time to listen to these owners on an issue we have a clear path on. But you know what? Really listening to the owners and having them feel that they've been heard, even though you might not be able to do what they want you to do, is really important, okay? And that will serve you really well. Don't let your ego or anger get in the way. I see that happen. It's unpleasant. Don't be a bully. Sometimes I see in boards where, you know, you have the lifetime director who's been the president of the board for 30 years, and they run the show, man. And they'll bully anyone who might not agree with them. Don't go down that road, you know, and call out people who are like that. And always, always, always act in the best interest of the association, and then you're going to be in good shape, okay? Okay. All right, so homeowners, also, here's good tips. You know, be good neighbors. You know, I'll tell you, I guess I'm 60 now and I don't have patience for it. But, you know, the owners who, you know, I call them the neighborhood police. They're always looking out for somebody who's violating something, and they're reporting them, their other neighbors. You know, come on, guys, we live in a community, right? HOAs need to be functional communities. So don't be the person jumping up on, you know, the wooden crate to look into their neighbor's backyard. Attend board meetings and stay informed. Board meetings are open. You have a right to attend. Go there and be informed. Don't jump to conclusions and assume the worst. That seems to be the thing in our society right now, I think. Don't assume that there is a grand conspiracy going on with the board. Typically, there never is. Well, sometimes, but rarely. And you know what? The way you get around that is you, as homeowners, also listen. I mean, really listen to what the board is saying and their thought process in making decisions. Comply with the use restrictions and rules. Know what they are. I mean, I would say 9 times out of 10 people violate rules or use restrictions because they don't know they're there. It's really rare that you have someone that's, you know, going to give you the finger and say, I'm doing it whether I can or not. That's not very often in associations. Be part of the solution. So those of you who have never been on a board, it's the worst compensated position in the world. You get nothing but sometimes grief, right? You're trying to govern your community, you're trying to do the best things for your community, and then you have the Monday morning quarterback folks that never attend the meetings, don't know what's going on, but they pass judgments and they stir the pot. So don't be one of those. And you know what? This is important. Run for the board. Serve on the board. If you have issues, run for a position on the board. Go ahead, Cindy. So HOAs can be a great place to live, and honestly, I really think 99% of them are, really. Or they can be a nightmare if everybody's at war in a community. That's not fun. So it's your choice on how you want to make your association in terms of a livable environment. Okay. Thank you, A.P.C.H.A, for having me. Good to see you. Yes?
I have one question as we get near your end. Do you have any guidance on if HOAs are required to report under the new consent?
Yes, they are. Yes. All right. All right. It's called the Corporate Transparency Act. The United States Congress, in all their infinite wisdom, they finally did pass a law, and it's called the Corporate Transparency Act. And what they're trying to do, and it basically affects every type of business and organization if you're incorporated in any state. And the thought process is with the Department of Treasury that they're trying to stop money laundering, is my understanding. I mean, who's going to money launder through an HOA when you have $20,000 in your bank account? But anyhow, FinCEN is, and by the way, one of our attorneys just did a training on it, and it's on Zoom, and I'm going to send it to Cindy, and she's going to put it on the A.P.C.H.A website along with the PowerPoint so you can watch it. Anyhow, beginning on January 1st, 2025, HOAs And members of boards of directors and management, in my opinion, are classified as beneficial owners because they govern and they have responsibility for governance of these communities, have to file with the Financial Crimes Enforcement Network. It's capital F, small I, small n, capital CEN. If you Google Corporate Transparency Act, you will get a link to the FinCEN site. And the association has to report its legal name. If you're doing business as another name, which most of you aren't, that would be a DBA with the Colorado Secretary of State. You have to report that. The street address that you use for the registered agent for your principal place of business, your jurisdiction of formation or registration, which would be Pitkin County, Colorado, and then your taxpayer ID number. And that is registered with FinCEN. Then directors and managers have to also file with FinCEN, and it's your name, your date of birth, your residential address, and you have to have an identifying number from either your driver's license or a passport. I don't know what they're gonna do with all this information, just have it in case they think an HOA is money laundering. But the good news is, I think, is, have you heard of Community Associations Institute, a national trade association for HOAs? They filed a lawsuit, a federal lawsuit, to have this declared unconstitutional. It's already been declared unconstitutional for like apartment buildings, is my understanding. But they are also seeking an injunction to stop the registration, and that hearing on the injunction, I think, is like October 9th or 10th. So we'll keep A.P.C.H.A updated on whether that needs to be done. But if they don't get an injunction and it's not declared unconstitutional, then beginning January 1st, 2025, that's when the registration has to happen. I'm sorry, I forgot all about the Corporate Transparency Act. Yes?
So is it your opinion all HOAs have to comply with?
Yep.
Okay, I work for a private management. We were suggesting to our individual associations they get their own legal position. So I was actually going to come to you about
Yeah.
specifically.
Yeah, and there's some, if you don't, there are some pretty stiff fines for doing that. By January 1st, 2025. I'm hoping I'll be able to report to you all that you don't have to, but yeah. Yes, I do developer work, so I create documents for new communities. And I just did 2 new projects, and as soon as we filed for nonprofit status within 30 days, you're right, we had to do the FinCEN filings with the Department of Treasury. But all of you are existing HOAs, so if you're an existing HOA, it's January 1st, 2025. And honestly, I don't think FinCEN has a clue as to how they're gonna enforce this against hundreds of millions, probably, of these companies that have to register. So, but we'll keep A.P.C.H.A up to date so that you know, and we will have Lindsay Smith, an attorney at our firm, did a Zoom meeting on it. And I'm going to send the link to the Zoom meeting that you can see the recording of it. So if you want to watch that, you can do that. Yes?
Every member of the board?
Yes, every member of the board. They're all directors. So, yeah.
If you're not director, if you're secretary or...
Those are officers, but they're also directors too. So, yeah, I mean, I would say all members of the board and managers, in my opinion. Okay?
I just have a question back on the examples of breach of fiduciary duty.
Uh-huh.
On the failure to enforce these restrictions
Uh-huh.
that are in the governing documents.
Yeah.
So how does, since that's my situation, how does, as a homeowner, most of this is directed at your director. I'm a homeowner with a board that won't do anything, won't enforce anything. So they're negligent in their fiduciary duty. So what do I have to do? I mean,
You could do a petition to have the board removed. I mean, you could go through the removal process. I mean, what I would do is educate yourself. Is it they refuse to enforce, or the new laws that went into effect have made it impossible to enforce? New laws went into effect in 2022, which make it really difficult to enforce.
But a neighbor can enforce the rules,
Yes.
not a neighbor.
Yes.
Right. Even
Yeah.
if the board and the county approves of what I can do, the neighbor can say, you can't do that.
And they can bring a lawsuit
And they can
against,
bring a
yeah,
lawsuit,
yeah,
regardless of approval from the county or
yeah,
and the board.
yeah. I mean, I would think that would help with the defense, but, yes.
I have a question regarding transparency. So, I'm new on the board, and I was told that the board is not allowed to have all the contact information, email addresses to all the homeowners. Because I typed up an agenda for the meeting with, important numbers regarding contracts that were going to be discussed. So I wanted everyone to understand what these numbers were, what we were gonna discuss. A spreadsheet with savings by changing some things around.
Uh-huh.
And I was told I'm not allowed to do that.
I disagree with that. I think you are allowed to do that. I know you are, okay? So, here's something everyone should know. Owners cannot so in order for an association to disclose to owners email addresses or telephone numbers of other members, the members have to give written consent to do that. But boards of directors, in my opinion, have absolute access to that information for the purposes of the work the board is doing.
So how we did that, because the same thing is that I have to put everybody on one carbon copy. So
Uh-huh.
ECC all of the owners, and that way there's a privacy, if there's any privacy.
Yeah, like you wouldn't put everybody's email address out in the two. Yeah, you do a blind copy, yeah. Yes, in the back of the room?
Can reserve funds be invested?
Yes, as a matter of fact, you're supposed to have a reserve investment policy. I typically recommend, make sure your reserve funds are tiered, so when they are needed, you can draw money from them. We normally recommend more conservative types of investments that protect the principal of the reserve funds, so that, because people are usually contributing through their assessments, so you want to really be pretty conservative about how you invest. And your reserve reserve investment fund policy should cover that. Yes?
Okay. It seems that many HOAs have the same question, but don't feel they're big enough to get a lawyer to look into it. Therefore, I'm trying to put everybody together. Charlie@charlie.coffee. Send me your 3 biggest issues that you're working on. If we all are having problems getting our financial numbers together, we'll get one lawyer to send out one letter for all of us. So, I will do that. So send the 3 biggest things you have. I would like to find out about this, and this. I will collate it, and if we all have 2 of the same thing, we'll talk about getting a lawyer to look into that as to what we could do as a big group as opposed to a bunch of little. Is that okay? Yeah. Charlie, Charlie. Coffee, a lot of coffee.
Coffee, COFFEE. Yes, there's a gentleman in the back.
We have a question, we have declarations and we have bylaws. Bylaws and declarations don't align completely. Our declarations are recorded, our bylaws are not.
Right, which is appropriate. You never record bylaws.
So what's the applicable path? Do you want to use declarations or do you want
If there's inconsistent provisions, your deck is gonna trump your bylaw provision.
to say that again?
Your declaration provision, if your bylaws, provisions of your bylaws and declaration are inconsistent, your declaration will trump your bylaw provision. So follow your deck provision.
What if they're not inclusive of the bylaws?
What do you mean?
There are rules in the bylaws that aren't in the declarations.
there's a ton of stuff in your bylaws that shouldn't be in your declaration. Remember, your bylaws are your governance document, how boards are elected, number of directors, qualification of directors, membership meetings, notice of meetings, all of that is in your, it should be in your bylaws and is never in your declaration.
So we share a property with some other homeowners, and we share access, and we have bills that we share. But those are not in our declarations, those are in our bylaws.
It's a really old community.
23 years.
Huh, it's in your bylaws. Usually when you have, and they're not part of your HOA, that usually you have what's called a reciprocal use agreement that is a contract between both communities that talks about what the responsibilities are and who pays what. It's a contract, but I'd have to see your bylaws, but, you know, I can't tell you based on the description. It might have been a developer of two communities, the same developer that put that in both of the bylaws. Yeah. Are you guys fighting over who pays what?
No, but
That's not unusual.
there are questions about maintenance, and we collect money based on the bylaws, but the bylaws,
Are you sure it's not your declaration?
no.
It's your
in the
bylaws.
So it makes it a challenge to have a disagreement with those that aren't in our declaration.
Mm-hmm.
To say, well, no, you can't do this because of, and I got nothing.
Yeah. Do you have a lawyer? By the way, I'm not asking for clients. I want to be, you might need some legal help to unwind that. Yes.
Are the bylaws the same as the rules and regulations?
No. Although some really, so you've got some, I have documents that were drafted here in Aspen that were prepared before I was born. So there's some really old stuff. And sometimes in old bylaws, you'll see rules. But if you ever do what's called amend and restate, meaning rewriting and modernizing your documents, I pull all that stuff out of bylaws and put it in the right document. In the correct document. But if it's an old community and the rules are in the bylaws, that's fine.
So rules and regulations then are part of the bylaws? They're not part of the declaration?
Rules and regulations usually aren't part of either. They're usually a standalone document of its own.
Okay.
Is that lower than bylaws?
Is that what?
Documents, bylaws?
So articles of incorporation, declaration, bylaws, rules and regulations. Yeah,
So protected covenants, what is that?
that's in your declaration.
That's in the declaration.
Yeah. Yep. Thank you for coming. All right.